Cuomo has been summoned to appear in Albany City Court on November 17th, but the former governor has not been officially indicted. That determination will ultimately be made by the Albany County District Attorney. And get this, the DA's office said it was unaware that the complaint was being filed today. So where does this leave us? Joining us now is Todd Kaminsky. He is a New York State Senator serving as a Democrat. He's also a former Assistant District Attorney. Todd, thanks so much for coming on the show. Really appreciate it. All right, a lot to unpack here. So first of all, where are we right now in this case legally?
Well, I think what happened was that the document that was filed in court that perhaps may not have been public right away, but was revealed, kind of shows where this is going. And that is that a summons is going to be issued for the governor's, for the governor to come into court to face a criminal charge. Now, what you just brought up about the district attorney not knowing it was filed today is the key word, because I would be shocked if the Albany district attorney did not work with the sheriff's office to be ready to bring this complaint. Of course, a sheriff's office or law enforcement could file a complaint on their own without the DA, but it would be highly unusual and really, I think, poor practice to drop a case on the DA's lap without the DA working with you from the beginning, ready to accept it and move forward with it. So I think that word today you used, Dan, is key. I think the DA was ready for this and will be ready to prosecute this case. The question was whether today were they ready for it to be filed publicly.
Well, so the DA is saying on Twitter that he learned about this like everyone else when this was made public. Said he didn't know that this was coming. But I want to read you, because I'm going to get to that in a minute with Aaron Keller, but I want to read to you from the statute, because I think that people may be under the false impression that this is going to be pretty easy to prove. And the statute is as follows. A person is guilty of forcible touching when such person intentionally and for no legitimate purpose forcibly touches the sexual or other intimate parts of another person for the purpose of degrading or abusing such person, or for the purpose of gratifying the actor's sexual desire. Now, we saw in the complaint that they used language that almost mirrored that, but that's not an easy type of case to prove.
Well, you are correct about that, but this case takes a whole other dimension and really raises the stakes, because I cannot imagine a world where the former governor does not try to take this to trial and try to discredit the accuser. And first of all, I just have to back up and say that I give the victim here a lot of credit for coming forward with this. This is going to be highly public. I do think the sheriff believes her. They've corroborated to the best they can her account, and they're ready to go with this. And as someone who's prosecuted former public officials, I prosecuted a Congress member, a Senate Majority Leader. When you bring cases against someone like that, of that level, you have to be ready for a war. It can't be, oh, we'll do some of it now and do some investigation later, or maybe they'll take a plea and we won't have to be put to the test. You have to be ready to have all of it put through withering scrutiny. And in this case, with the best attorneys that money can buy in a public court. So this is going to be, I think, a protracted legal drama, even though it's just a misdemeanor. And I think there's going to be withering scrutiny brought. But I think that, what the sheriff's office is telling us today through their actions is they believe they're ready for it. They believe the victim, and they're ready to corroborate it and bring it into public view.
Now, the former governor has responded. His attorney, Rita Glavin, has made a public statement saying, quote, Governor Cuomo has never assaulted anyone, and Sheriff Apple's motives here are patently improper. Sheriff Apple didn't even tell the district attorney what he was doing, but Apple's behavior is no surprise given, one, his August 7 press conference where he essentially pronounced the governor guilty before doing an investigation, and two, his office's leaking of grand jury information. This is not professional law enforcement. This is politics. Do you think that now the DA is going to be under political pressure to move forward and file this case regardless of what the legal determination is?
So I still don't think we know how much the DA was involved in this investigation at all. It could be none. It could be. It would be highly unusual not to be. But if this was really dropped in the DA's lap, the DA has to do real investigation. You cannot bring a case as a DA ethically if you don't believe that that the charges are there beyond a reasonable doubt. You obviously have to believe the victim. You have to believe that a crime was committed, and you have to be willing to take that to a jury. That's the bottom line. Now, of course, in many cases, many that I prosecuted, the defense wants to impugn the motives of the government. And that really depends on how much a judge is going to let that in. But at the end of the day, it comes down to whether the jury believes the victim and whether there's corroborating evidence supporting her charges.
But again, the challenge here is that you have to be able to prove not just that it happened, but that the person did it with the intent of degrading or abusing such person for the purpose of gratifying the actor's sexual desire. That is part of the statute, part of what they would have to prove in court here, which I think that's the part that, again, is going to be a challenge if this goes to trial.
There's no doubt about it. And remember, the public knows some of the allegations from the Attorney General's report with other victims. In other words, when you view this as a pattern about what he might have said and done with other young women, that might seem a little easier to prove, but it's far from certain that evidence could come in a trial. And that's something that's going to happen.
And that's a great point, because I would bet that in the context of this case, with this evidence, that a judge probably will not allow evidence of other, what do we call other bad acts. It has to basically be similar enough in nature that it shows a pattern of conduct. I don't think the judge is going to allow that in. So I guess my point here is I think people are underestimating how hard a case this is going to be, regardless of whether you think it happened. I think that the proving it in court is going to be a real challenge here. And let me do this. Let me bring in quickly Aaron Keller. He's an attorney, senior editor for the Law and Crime website, which I founded. He's been tracking the allegations closely against the former governor. He's got some fascinating insight tonight in an article that he wrote on the Law and Crime website. Aaron, you wrote in your article that the sheriff has used here a rarely used procedural mechanism which allows him to go straight to the court and not through the DA. Talk to us about that.
Dan, this was such a rare situation that several experienced, seasoned attorneys in New York State that I talked with when preparing the report basically said that they were shocked that this procedure was even used. But I do have sources that walked me through it and said, look, it is possible in this sort of situation with a misdemeanor information where the sheriff can do basically exactly what he did here, where he gets his officers to go to the court and the court issues a summons for the defendant to appear. And that's what the sheriff said happened here. This process is a stark departure from what we normally see in New York State, which is where a law enforcement officer writes an appearance ticket. And then the person is given a couple of weeks to show up to court and, other booking procedures are done at that point. So this is very procedurally awkward. It's very different from what most New York people, even seasoned New York people, are telling me that they usually see in the Empire State. So the question is, why did the Albany County Sheriff Craig Apple take this specific tactic in this case? Why did he go around the DA's office? We don't know the answer to that, but we know that's what he did.
Well, and Aaron, we know that the DA tweeted out, like the rest of the public, we were surprised to learn today that a criminal complaint was filed in Albany City Court by the Albany County Sheriff's Office against Andrew Cuomo. And so that suggests to me that you've got a real problem going on here between the sheriff and the DA in the case against Andrew Cuomo. But let me do this. Let me take a quick break here. Senator Kaminsky, Aaron Keller, stick around because we're continuing to cover this. One of the questions I still don't understand is why aren't more people covering this? I mean, I was looking up on cable news when this broke, and I was thinking, why isn't this everywhere? And yeah, there was a little mention of it here, a little mention of it there. But why isn't this a bigger deal? Is it because of this sheriff versus DA? Anyway, take a break, come back in a moment. Continuing to cover the breaking news that a charge has been filed by the sheriff in Albany County against former Governor Andrew Cuomo, accusing him of forcible touching, which is a Class A misdemeanor, the possibility of up to a year in jail. But there seems to be a lot of confusion about exactly how this happened and why it happened now. attorney and senior editor from Law and Crime. Aaron Keller is back with us, as well as Todd Kaminsky, who is a former federal prosecutor. Gentlemen, thank you again for coming back. All right. Aaron, we were talking about how unusual this is, and you pointed this out in your article about talking to a number of seasoned attorneys saying they'd never seen anything like this. Are you getting the sense that there is some level of conflict between the sheriff and the DA about this?
We'd be speculating to go there, Dan, but it's an educated speculation, right? Because this departs rather severely from the normal practice. Again, my people are telling me it is legal. It's in the criminal procedure law of New York State, and I cited to some of those laws in the piece on lawandcrime.com. But why did it happen this way? As I said before the break, that's the big question. Was it because the DA was, in the opinion of the sheriff, stalling the investigation? Or did the DA have a good reason to stall? Remember, there were 11 accusers pointed out in the Attorney General's report that came out against former Governor Cuomo over the summer. So did the DA want more investigation on all of those accusers and then potentially, hypothetically, to file a case involving more than one accuser here? Why? We just don't know. But it's a tip of the iceberg situation. There's something going on here. We just don't know all of it yet.
Todd Kaminsky, now that you've heard Aaron's assessment, any better sense of what you think is going on here?
Yeah, I think, look, there's definitely some communication breakdown for sure. The question I have is, how much was the DA involved in the actual investigation? In other words, was the DA sitting in on interviews, reviewing the evidence with the sheriff, kind of doing everything together? Or is this something the sheriff did and just dumped in the DA's lap? Those are two very different situations. In other words, if the DA was along for all of this, speaking every day, conferring, going through evidence together, and the sheriff just took an act that the DA might have expected to happen at some point, but not now, that's a different story than the DA being totally out of the loop. And we don't really know which is happening here, but there's obviously something wrong and something unusual.
Well, I will tell you my theory here. My theory is that the sheriff is trying to put pressure on the DA to bring these charges, because as far as I'm concerned, there's no other reason why the sheriff would not be working with the DA in connection with this. As you point out, they're working together, I'm certain, with regard to knowing where the investigation stands, et cetera. This feels to me like a power play by the sheriff to force the DA's hand. But I have to say that there have been only 2 CNN references, 1 MSNBC reference, and 1 Fox News reference to this story. After all the coverage we all did of Governor Cuomo for weeks, we now have a sheriff filing a criminal charge, and I have no idea why no one seems to want to cover it.
Anyway. Let me put my political and legal hat on. Politically, I think now that he's not the governor anymore, it doesn't have the same fall from grace news story that people want to tell, which I think is unfair. I think that's what you're saying. But also, let me say legally, if your theory is correct, and we're all speculating, that does not portend good things for this case. You cannot force the DA to do something the DA doesn't believe in. And if the DA does bring a case to court that it doesn't think is ready, it's not going to go well, and it's not ethical. So the communication breakdowns you've talked about tonight are very troubling. But it is possible that the DA and the sheriff only had a timing issue, not a substantive issue.
Well, we'll see. We'll see. I'm more conspiratorial than that. Senator Todd Kaminsky, thank you so much. Aaron Keller, great work on this story. Honestly, if I hadn't been able to read your story, I wouldn't have totally understood what was going on here. So thank you. Appreciate it. Coming up, the word victim has become a huge issue in the highly politicized murder trial of Kyle Rittenhouse. A judge says prosecutors can't use it since the defendant is arguing self-defense, so maybe they weren't, quote, victims. That makes legal sense to me, but my guest says the judge is trying to ensure Rittenhouse walks free. We'll debate. I would prefer that the judge say, if you can prove it, then you can certainly refer to the acts they engaged in as, quote, looting, arson, and rioting, rather than the name calling. But I also don't think it's that big a deal, nor do I think it will ultimately impact the outcome at all. Joining me now is someone who disagrees with me, Elie Mystal, justice correspondent for The Nation, who has written an article entitled, "I hope everyone is prepared for Kyle Rittenhouse to go free." And then the subhead is, "Even if Rittenhouse somehow draws an impartial jury, he already appears to have landed a very partial judge." Appreciate you coming on the show. What am I getting wrong here?
Yeah, so let's start at the beginning, right? We know that these people are victims of a homicide. That is just a legally flat term. There was a homicide. They were alive once. They are dead now. We know why they're dead. Kyle Rittenhouse shot them. Now, the trial of Rittenhouse is to determine whether or not that homicide is justified. And he is entitled to a fair trial with due process and the presumption of innocence. Blah, blah. He's entitled to all of that. But the truth of the matter is a homicide occurred. So these people who were alive, who are no longer alive, were victims of a homicide. That's just a flat, legally accurate term. Now, Judge Schrader.
Well, let's start on that one, though. Let's start on that one. Just on the victim issue, because I know you have nuanced positions on depending on the words here. But let's focus on the victim piece first. So you're saying that because they were, and you're right, legally as a homicide means death at the hands of another, right? Period. No question that it was, quote, a homicide. But it does seem to me when you call someone a victim, let's take it out of this case. Let's not talk about another case where someone was clearly the aggressor against someone else, and in self-defense, they shot and protected themselves from being harmed by the other person. You're still ready to call that person a victim?
Well, this is what happens in most trials, right? Somebody comes through my window right now, I bang, bang, shoot them dead, and now I have to go on trial for self-defense, and the prosecution is going to say that my victim came through my window, right? Like, I'm not going to like that if I'm a defense attorney, if I'm the defendant or the defendant's attorney. There is a progressive case to do what Judge Schrader did, to not allow prosecution to call victims of homicide victims in the context not just of a murder trial, but in the context specifically of a self-defense trial. I take his point. I see the rationality of his point. Schrader himself, however, says most judges don't agree with him. Most judges don't do this. And certainly we have no evidence of other judges in Wisconsin making this same decision, right? So Schrader is already telling us he is doing, and whether or not that's a longstanding principle of his, whether or not that's a good idea of his, he's already telling us at the outset that he is doing something in this case that is not a standard thing to be done in cases of this nature. So that's something to consider, right? That's an issue that people are right to point out. Again, that is even if you agree with the overall decision and how it should or could play out in criminal cases going down the line. Schrader himself is saying he's doing something a little bit different that most other judges don't do.
Now, do you agree with me that if his ruling was, forget about the name, the rioters, arsonists, et cetera, I don't really like that kind of name calling to allow that in court. But if there is evidence to demonstrate that there was rioting or arson, et cetera, and he presents that as part of his defense in this case, it seems to me that's certainly relevant.
Well, no. Well, here's the thing. Again, we're in a self-defense situation. We're in a situation where the homicide is uncontroverted, and Rittenhouse is arguing justification for that homicide using prior bad acts of the victims of the homicide.
It's the current bad acts. It's the current bad acts.
Did they loot his house? Did they arson his house? Did they riot in his house? No, of course not.
But we're not talking about the castle doctrine about his house. I'm saying that they're not going to present a defense that it happened at his house. They're going to present a defense that it was happening as this was going on, and that's relevant to the circumstances surrounding which he found himself.
How is what these people were doing not to him relevant to whether or not he was in fear of his life and he needed to use deadly force to protect himself? How is setting a fire 4 blocks away relevant to the question of whether or not Rittenhouse had to shoot them to death? So I don't want to I'm not ceding the ground even that these people should be called rioters or looters or arsonists, because as you keep saying, Dan, you keep saying that the judge is saying if they can prove that they were rioters and looters, then they can use that evidence. Well, the victims aren't on trial. So proving that they
wait. In a self-defense case, inevitably the victims will be on trial. in a self-defense case, that's the way it works. You know that as well as anyone. To say that the victims aren't on trial is living in a fantasy world. That's what happens in self-defense cases, no?
The victim's morality isn't on trial, number one. Number two, there are 3 victims here. There are 3 people he shot, right? The
Yes.
2 people who are dead and the one that he was just shot in the arm. It is relevant, I believe, that while the defense might want to try to prove that the person who is still alive was a rioter or a looter or an arsonist, that person has not been charged with rioting or looting or arson.
Right.
So how can you tell me that the judge is going to allow Rittenhouse to prove that this man might have been a rioter, looter, or arsonist when the legal system itself has brought no charges calling that person a rioter or a looter or an arsonist?
I'm going to give you the final word on that one, but I want to ask you one final question, which is, do you think it is fair to say that you have already decided what you think the verdict ought to be? I mean, when I read your article, you know, and I read a lot of your stuff, you do a lot of legal analysis, et cetera. You wrote in your piece, in a just world, Rittenhouse would just go to jail for a double homicide and illegal gun possession. But we do not live in a just world. We live in a white one. It sounds like you have decided what you think the outcome should be. Fair?
Oh, absolutely. Yes, absolutely. I've decided what the outcome should be. I should not be a juror in this case.
No,
I
I
should
got
not
it. I got
be a judge in this case.
Totally.
Right?
Look, and by the way, I'm not one of these people who suggest that everyone in the media needs to be objective. I think it's so phony to suggest that everyone in media has to somehow be objective. I just wanted to lay that out there to make sure that you would admit that, which you do, which I think is very intellectually honest.
It helps my case if this kid gets the fairest trial possible. That's the point of the legal system, right? Like I want him to go to jail, and I want him to go to jail under the fairest system possible, so that when he is in jail, people are like, oh, well, he got his shot, he got due process. That's what I want.
All right. Elie Mystal, thank you so much for coming on the show. Appreciate it.
Thanks for having me, Dan.
Time for our police cam segment, showing you the dangers police face every day across the country. We're about to see the chain of events that began when police investigated a vehicle at a shopping center in Tallahassee, Florida. An officer on patrol saw a Volkswagen SUV in the shopping center's driveway with 2 men, a woman, and a child inside. The driver told police he was checking the gas cap. An officer found marijuana in the vehicle. The owner didn't have a medical marijuana card, so police asked him to step out. They investigated. The man in the back seat, Raheem Reeder, jumped into the driver's seat, put the vehicle in reverse, and hit the gas.
No, wait. No. Get out of the driver's seat, man. Don't drive off. Don't you drive off. Oh. This man.
See it again from another officer's body cam. An officer was knocked over, you saw that, by the passenger door as Reeder sped off, going the wrong way on a one-way street. The vehicle was found unoccupied less than an hour later. As police looked for Reeder in nearby homes, a woman came running out of an apartment screaming for help, saying Reeder was holding hostages at gunpoint.
What's going on? Hold it down. She said they got him hostage in here. Hostage in here.
Answer, please.
Let me see your hands.
The woman, who actually was a hostage herself, was able to escape. Meanwhile, as officers went to the front of the apartment, another officer ran to the back of the building.
Hold your traffic. They're giving commands. Just everybody hold it tight. Don't move.
We stopped the video there. Reeder jumped through a second-floor window with a gun in his hand that he grabbed from the home. He pointed the weapon at the officer, who fired 2 shots, hitting Reeder, who died at the hospital. Police at the front door rushed in, thinking Reeder had fired the shots. You can see the window broken out as Reeder jumped. The woman and girl held hostage were uninjured. With me now to take us through this chain of events again, Sean Stix Larkin, retired Tulsa police lieutenant, former co-host of Live PD. You know, Stix, that was one difficult scene to watch.
Yeah, there's so many different things that are going on in this from beginning to end. And I know you said it all happened within an hour. From my understanding, it was roughly about 14 minutes from the time at the scene of the car stop until the shots are fired there at this apartment. So it goes from an officer checking on a vehicle that's just parked a little bit out of the ordinary. he has a consensual contact with these guys. And then you see an officer get hit by a car that ends up leading to a hostage rescue type of situation that fast.
And, we've talked about this many times about how some of these things start over something incredibly minor.
Time and time again, that's part of policing. Guys being proactive, seeing something that kind of raises suspicion, something out of the ordinary, and they get out and just make that basic contact with somebody, a consensual contact, or they have a legal reason, to stop a car, do what we call a pedestrian check, something like that, something very, very small that has very, very huge results there in the end. And what I want to point out that's really good what the officers did here. On a hostage rescue situation, if they believe that the victim is in imminent danger, which they believe these shots were fired inside the apartment, they didn't hesitate. They went straight in, risked their own lives to try to save who was inside.
Sean Stix-Larkin, thank you very much for coming on. We'll see you again very soon.
Yes, sir.
Coming
Thank you.
Attorney General Merrick Garland. The guy can't win. First, it was the left slamming him. Now the right's yelling at him. Could that just maybe possibly mean that he's doing something right? Coming up. Anytime I see someone at a high level getting blasted by both sides for political reasons, it's going to get my attention. And I'm going to be inclined to say that the person's probably doing something right. Garland has been described as a radical institutionalist, a true believer in the checks and balances put in after Watergate by addressing certain Trump-era policies on a case-by-case basis, leaving certain decisions to Inspector General, the DOJ to handle other issues. It seems like by not going after the Trump folks, meaning the legislators, even Donald Trump himself, he's trying to depoliticize the Justice Department. He's trying to restore public confidence in the rule of law. Here to tell me why I'm wrong on one side of this is Ankush Kadori, an attorney and former federal prosecutor. Thanks very much for coming on the show. His latest piece is called Why Merrick Garland Going Easy on January 6th Defendants is up on Politico. Now, you say he's sort of going easy on them. I read your article with great interest, and it seems that in particular, your focus was on the fact that a lot of the lower level people have been charged with lesser crimes, and your point was that as federal prosecutors, they could have charged them with the maximum possible under the law. But it seems to me that they've done the right thing here by trying not to make the political divide in the country that much worse by just doing the maximum that's possibly within their power. Am I wrong?
I think you're right about that. The concern that I have and that I articulated in the piece is that it's not just that they should be charging them under these sort of maximal theories just for the sake of it. That's what the Department of Justice's policy actually is, to charge people with the most serious, readily provable offense available on the facts and to require them to plead guilty to that sort of offense. So that would include a felony rather than a misdemeanor, assuming that the facts give rise to those two different sets of potential offenses. Now, I happen to think that the DOJ's charging policies are a little too rigid and a little too harsh. What I don't like is that this particular class of defendants involved in the January 6th riots seem to be getting more lenient treatment than every other criminal defendant in the system. I would rather he just actually...
Do you really believe that? I mean, you really believe it? I mean, for example, there are no deferred prosecution agreements in this at all. And you can say, well, that's what we do in the federal system, et cetera. But, there's been a mandate that says none of them get deferred. People who walked into the Capitol for 30 seconds are being charged with, serious crimes here. And again, I'm not saying that was the case with all of them. Don't get me wrong. Anyone who engaged in any kind of violent activity, even property damage, I fully support throwing the book at them. But the people who just sort of followed along here, they're getting charged. This idea that, we should be throwing the book at these people who just walked in and didn't do anything just seems to me to be the wrong way to look at this.
No, I agree. We should not be throwing the book at those people. We also should not be throwing the book at the people who are being charged with crimes unrelated to January 6th. This is a violation of Merrick Garland's principle that there should be even-handed distribution of justice. And by the way,
people don't get the book thrown at them for trespassing. They just don't. I mean, the Capitol's different, but people don't get the book thrown at them for committing said whatever, crime of parading, the trespassing, whatever it is, for 30 seconds or so. And it sounds like you're saying it's all equal, but it's not. The facts matter and the context matter. And it seems like you're kind of ignoring it.
No, look, this was an unprecedented event. I don't think we're going to find an analog, and that's part of the problem. But I'm not alone here, right? There was the chief judge in the court today criticized the department because she said she couldn't make any sense of their charging decisions. And in fact, she sentenced someone to probation over the objection of the government because she felt like that was an approach that was the actual consistent way to treat the defendants, given the way the government had been treating them. So I don't think that I'm alone in having this concern. Her principal concern, which she's articulated multiple times now, is that the government is setting a bad precedent for deterrence purposes. And that if we're not actually posing some real consequences here, it's just going to happen all over again.
Yeah, well, I'm not certain that that's going to be the critical question in terms of the sentence. Ankush Karduri, thank you so much for joining us. Appreciate it. Coming right back. Thank you for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.